Well, good afternoon. We won't know the decision from the Illinois Supreme Court for some time now, and they did seem to push back on arguments made by both the special prosecutor as well as Smollett's attorney here this morning while they were giving their oral arguments. The hearing just actually ended about 15 minutes ago.
The question is, it is a dismissal with prejudice that precludes potential of future indictment, and the answer is unequivocally no. Under this court's longstanding precedent. And what's important, we can also just look at two other cases that we had cited that they just didn't respond to. That's the Gill case and the Ryan case. And the Gill case is very instructive, and it reads, quote, "Before a court may determine that the state is dismissing a charge with prejudice, what must happen? The prosecutor must clearly and explicitly state that she's doing so on the record." And the Ryan case, where this had come up and there was no express dismissal with prejudice, that had been overturned because, as the appellate court had held, that there was nothing in the record to show that the dismissal was actually with prejudice.
Now, Jussie Smollett did not join his attorneys at today's proceedings. His attorneys basically argued he should have never faced charges he was convicted on because Cook County State's Attorney Kim Foxx's office dismissed the original charges in exchange for community service and Smollett forfeiting his $10,000 bond. The actor has always maintained his innocence, but after an uproar, a special prosecutor was appointed to review the case. Smollett was re-indicted and found guilty back in 2021 on 5 counts of disorderly conduct and sentenced to 6 months in jail plus a fine of more than $130,000. The special prosecutor says the agreement never detailed any promise that charges wouldn't be brought again in this case, and they proved to 12 jurors that Smollett paid two brothers about $3,500 to stage the attack while yelling racist, homophobic slurs and telling him this is MAGA country. The two brothers testified against Smollett, and Smollett recently lost a case at the appellate court by a 2-1 decision. His attorney says Smollett is the victim of a racist judicial system, and the second trial, when he was convicted, should never have happened because he had a deal with the Cook County State's Attorney. The appellate court disagreed and ruled despite the original charges being dropped, there was never an agreement that the charges couldn't be reintroduced.
The pro se defendant had brought his life savings to court, $10,000 given the prosecutor in exchange for a motion state nollie process, and the prosecutor, who has the power to draft the instruments of his arsenal, says in court, motion state nollie process, and then comes back and says, got you, we have your money now, we've converted your property, but we're still going to prosecute you because we didn't use the right technical term.
So it's your position that the defendant on that date forfeited $10,000 to the city of Chicago with the understanding that when he left the courtroom, the prosecutors could rebring those charges against him?
Absolutely.
Now, once again, we will not know the court's decision for some time now, and even if Smollett does lose here at the Illinois State Supreme Court, his attorneys could take it all the way to the U.S. Supreme Court. We are live in Springfield. I'm Eric Rung, WGN News.